Hi, I'm Mandy Fitzsimmons. I'm your Washington REALTORS Legal Hotline Lawyer. Today's question comes out of our Legal Hotline Mailbag. The question is, I'm in a bit of a situation right now on the day we are supposed to be closing. The buyers are requesting the seller to fix a stain in the wood floors of the living room. The stain was not noticed until the buyer's final walkthrough, and it was not noticed by the seller until she removed her large rug and the furniture which had sat on that rug for the last 10 years. She just moved out last weekend and the buyers came the next day for a walkthrough. The seller does not feel obligated to repair the flooring as she was unaware of it until she moved her belongings, and the buyer feels like the seller should be obligated to pay for the repair. The buyer said it was misrepresented, although the seller had no idea. Can the buyer delay closing because they now want repair requests even though they waived inspection and it's closing day? Will the buyer lose their earnest money if they don't close by today? Does the seller have any options in this? Is the seller entitled to the earnest money if the buyers don't close today, or is the seller obligated to make the repairs in order to close? The answer is, whatever the Superior Court tells you is the answer to all of these questions. Because if this evolves into an unresolved dispute, and it results in either a post-closing lawsuit, buyer against seller, or a post-sale fail lawsuit over the earnest money, then a judge is going to hear this case from both sides, not just from the listing broker's telling of the story, but also from the buyer's telling of the story. All of the facts presented by both sides are then going to be subjected to legal argument by either the party themselves or the party's lawyer, if they're represented in court. And then a judge is going to run all of that information through the judge's own filter and reach a conclusion that is the answer to any or all of these questions that were asked. Brokers, I hope you recognize that when you find yourself in a situation like this, because I get this question probably in some form or another every single day. What can I do? What are my buyers, what are my sellers' options when either confronted with a post-walkthrough problem or even a post-closing or post-sale fail problem? Brokers, here's what I need you to recognize. There is nothing in any of these questions that were asked that has anything to do with the provision of real estate brokerage services. Yet, what you are licensed and hopefully insured to provide is real estate brokerage services. Unless you have additional licensing, you are not licensed to answer these questions, because answering these questions requires the practice of law. You are going to take the facts of the situation, you are going to apply them to the law, and you're going to reach a conclusion about buyers or sellers' options in either case. Does it seem like buyer has the right to delay the closing or demand that the floors are repaired if seller never had any knowledge of the defect in the floors? Well, it seems easy enough to say the answer to that question is no. Buyer can't. How is seller supposed to disclose something seller had no knowledge of? But do you think that's the way the facts are going to sound if buyer makes the argument in court? Probably not. So brokers, simply put, you cannot give your client legal counsel about what their rights and obligations are following buyer's walkthrough when buyer discovers something that makes them unhappy and wants to know, what are my rights in this scenario? What if seller misrepresented? What if seller committed a breach of contract? Seller was supposed to remove some toxic material and they didn't remove it. Seller was supposed to leave an appliance and they didn't leave it. What are my rights, buyer might say. Or in this scenario, buyer says, seller, you have to take additional action that you did not previously contract to take. And seller wants to know from the listing broker, what are my options? What's my recourse? All of those are questions that require legal counsel. A question I sometimes get when we're talking about forms is, why don't the statewide forms producers simply create the answer in the form itself? When buyer does their walkthrough, if the property's not in the condition that they thought it was supposed to be in, then the buyer's recourse is whatever recourse the form states. We can't do that. As statewide forms producers, there is no way to anticipate the right solution for any unknown set of facts. For example, what if buyer's complaint is that the property is no longer in the same condition it was when they agreed to purchase the property, notwithstanding seller's obligation to maintain the property in the same condition? Could the statewide form create an outcome that says, here's the buyer's remedy in that event? When the changed condition could be that the seller's movers knocked a 3-foot wide diameter in the living room wall as they moved the grand piano out of the house. That would be significant. But what if the changed condition was that the grass in the front yard is dead because the seller didn't water it the way the buyer thought that the seller should have been watering it? We can't create a statewide forms remedy for the incredible spectrum of complaints that could evolve based on buyer's allegation that seller failed to maintain the property as the buyer believed seller should, in light of seller's obligation to maintain the property in the same condition it was in. In every single scenario like that, brokers, you need to advise your client to seek legal counsel. Your buyer, your seller is asking you for legal advice. And the really hard part for real estate, for realtors, is that realtors are problem solvers. You are solving problems for your client from the minute they meet you and tell you that their objective is to buy or sell their house until they get to the closing table. You are knocking down problems for them every single day. So why not this one? Because this is not a problem that can be solved with the provision of real estate brokerage services. This is a problem that requires the practice of law to solve. It's hard to do, but in this case, you have to simply say, I'm sorry, client, I cannot give you the answers you're seeking. All I can do is advise you to seek legal counsel. That is consistent with your agency law duty, which is to advise your client to seek the advice of an expert in areas that exceed the scope of your expertise. If you have questions on this topic or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington REALTORS member.